Next, we're going to hear from Snyder about the legal issues.
I have 8 minutes to tell you everything you want to know about law. It is not going to happen, but I can give you an overview. My issue isn't going to be whether or not you can hear me in the back row. I did a lot of theater in my youth, so it's from the diaphragm. Talk to the back row. Whether I blow you guys out or not, that's another matter. I am going to try to give you some good information, but you will not get all the information you need from me. There are other professionals that are just as or more qualified than I am to sit up here on this stand and talk to you about the legal issues, including Victoria, John Weltman. John, raise your hand in the back. Melissa Brisman. Melissa, raise your hand. If you want to talk about legal issues, these are some of the preeminent attorneys in the area, and they're very, very helpful, and they will always be willing to chat. I am the chair of the American Bar Association Family Law Assisted Reproductive Technology Committee. That means that I kind of organize administratively all of the attorneys in the United States and many overseas that deal with intended parents just like you about the legal issues that you're going to face. One of the things that I have learned is that there are different definitions of what a successful surrogacy is. For a physician, it's the live birth of a healthy child. They've succeeded for you. However, this is very much a legal process. You're not going to be happy unless you have the live birth of a healthy child over whom you are the sole legal parent in your home jurisdiction. So the legal issues dictate the success or failure of your program, and you have to have a qualified attorney in the jurisdiction where the birth is going to happen, and perhaps in your own home jurisdiction, because there are issues about transporting those birth orders back home with you. So with that mission statement in mind, I just want to make sure that you're aware of what kinds of issues are going to face you. One of the most important questions I get is, from jurisdiction to jurisdiction, am I going to be the legal parent? Can the surrogate change her mind? Can the carrier keep my baby? The first thing you need to understand is that parentage, which is the important part to you, is governed by state law. You know how many states we have, that's how many different laws we have. So every time a surrogacy is conducted, you have to look at the law of every state that's relevant to that program. The one you live in, the one your carrier lives in. There are choice of law issues that your attorney will help you with, because if it's multiple jurisdictions, one may have a more favorable law. So you work with your attorney to evaluate the laws and make sure you're selecting the best law for your program. With that in mind, the question always is, as I just said, can she keep the child? Surrogacy is a really reliable process. You don't really need to worry about that if you are in a very responsible program with responsible professionals and a responsible agency. Over the history of surrogacy, as Melissa and John and Victoria and I monitor the cases, there are maybe 20 or fewer high-profile contested surrogacy cases in court over the history of surrogacy. And there are thousands and thousands of surrogacies. So your biggest fear is really your smallest fear. There was an anecdotal study done in 2002 that I read in a magazine article that said over 15,000 surrogacies, there were only 89 that had any kind of controversy at all, that didn't even make it to court. The surprising thing is 62 of those were parents that didn't want the child because they went bankrupt, got divorced, or the child was handicapped, or it was triplets and they only wanted one, or it was the wrong gender. Only 27 surrogates actually proved to be unreliable under those circumstances. So I want to allay any fear you have, regardless of what state you're in. If you use reputable attorneys and you use a reputable agency, you are going to have a safe journey in all likelihood. Put that fear to rest. The cases that most often don't work, and this is a message I have to give you from my heart, are the cases where you don't have the professionals involved. I have a sister that's going to carry my child. I found a contract on the internet. I can buy a home insemination kit for $49.95. I don't need those stinking professionals. I can't afford it. I'm going to do it the way I can afford it. And then you spend $100,000 in court trying to keep your baby. So in the end, it's really not cost effective. On the back end, to do it that way. So I encourage you all, please get a cadre of qualified professionals, agencies, attorneys, psychologists. Go through the proper steps. Surrogacy is a process from A to Z. Every step has to be done. They have to be done in order. They have to be done by people that know what they're doing. If you do that, you will be safe, I guarantee you. Your issues are, when the surrogacy is over, will I, and probably your partner, be the legal parents? Let's say that you have a surrogacy that has you living in one state and the carrier living in a different state. The question is, the birth records are going to be governed generally by the state in which the surrogate lives. Your parentage may be governed by different laws in the state where you reside, so that raises two issues. You have to look at the law that's going to govern the birth records to determine whether they will or won't put two men on a birth certificate. The minority of states will, the majority are either unknown or won't. When you select a carrier, you need to work with your agency and your attorney to make sure that the surrogate state of delivery will allow you to get that birth record in the names that you want it. And if not, the second issue is full faith and credit. Okay, now I'm talking constitutional law. You guys, how many are you attorneys? Okay, a couple of you know what I'm talking about. But constitutional law is, full faith and credit is, will one state give full faith and credit to the order a different state issues? So if you get a parentage order in Colorado, will New York recognize it? And depending on many features, whether you have a state that allows gay marriage, whether you have a state that has domestic partnerships affirmed, whether the state has a negative policy towards those things, will they recognize that court order when you come home? And there are multiple ways you can get parentage established. In California, you get it through pre-birth orders, so that as soon as the child is born, that order becomes effective, and then you go on the birth certificate. In other states, you may have to do a second parent adoption before you are allowed the non-genetic father on the birth certificate, and that process may be able to be done in the state of birth, or you may have to go home and do it. If you live in New York or a state that has laws particular to that, you have to know whether you can do it when you get home. So there are many pieces that revolve around the legal issues in surrogacy, and understand that a good surrogacy is based on a good legal contract. That legal contract is subject to interpretation from start to finish. The person that's going to do that interpretation for you and guide you in the process is your attorney. Find a good one, listen to them, and everything will turn out well. There are 102 other things I have to tell you, and I can't, because he just showed me the 1-minute sign. So, talk to John, talk to Melissa, talk to Victoria, talk to me, but talk to an attorney. And I cannot wish you with a warmer heart success on your journey, because I believe every parent in the United States that wants to have a child in their family unit should have that honor and that privilege. I have 2 children. They changed my life. Your children will change yours, and anything we can do to help you in that journey, that's why we're doing it.
Thank you.